So the state of Florida has approved the death penalty for crimes other than murder. So, Florida Governor Ron DeSantis signed a bill on Monday allowing Florida to impose a death penalty on those convicted of sexual battery against children. Now, this law is in direct violation of the United States Supreme Court decision in a case called Kennedy v. Louisiana. This ruling came down in 2008. Now, in this case, a Louisiana court found Patrick Kennedy guilty of sexual battery against a child. Now, state law allowed the district attorney to seek the death penalty for defendants found guilty of any type of sexual assault crimes against children under the age of 12. The prosecutors sought the death penalty, and the jury unanimously awarded the death sentence to Mr. Kennedy. In 1977, in another Supreme Court ruling, the case is called Croker v. Georgia, the Supreme Court had struck down capital punishment for sexual assault cases where the victim didn't actually die. Now, Kennedy argued that this precedent of Croker made it unconstitutional for him to receive a death sentence because the victim actually lived. Now, Louisiana countered, arguing that the unique vulnerabilities of children justified imposing higher sentences in most cases, in assault cases, in gun-related cases, in anything. If the victim is a child and a perpetrator an adult, then there's generally an enhancement of the penalty. And this is no different. If an adult does this type of crime to a child, then the penalty should be enhanced, and one of those enhancements could be the death penalty. Now, we have to understand where the court is ideologically at this point in time. Right now, the court is a majority liberal court. It has 5 liberals and essentially 4 conservatives. Those conservatives are Chief Justice Roberts, Anthony Scalia, Justice Thomas, and Justice Alito. Now, in a 5-4 decision where all 4 conservative justices dissented, the court is going to answer this question directly, whether the precedent of Croker, where the Supreme Court said it was unconstitutional to have the death penalty levied against someone in a crime where the victim didn't die, whether that also would apply to children. Here's what the court had to say.
The case that we will discuss briefly here, which is Croker versus Georgia, an older case dating from 1977. In Croker, the court held that the death penalty could not be imposed for the rape of an adult, where the crime did not result and was not intended to result in the death of the victim. The case before us, of course, involves the rape of a child. In these and other cases discussed in the opinion, the court was guided by objective indicia of society's standards as expressed in legislative enactments and state practice with respect to executions. We follow that same approach here, based both on consensus and our own independent judgment. Our holding is that this sentence does violate the 8th and 14th Amendments. The Louisiana statute is unconstitutional. The number of permissible executions could not be reconciled with our evolving standards of decency and the necessity to constrain the use of the death penalty. We hold that, as it relates to violent offenses against individual persons, the death penalty is disproportionate and an excessive punishment where death did not result from the crime.
Now, the voice that you just heard was Supreme Court Justice Anthony Kennedy reading the majority opinion. Now, the conservative justices, including Justice Thomas, Scalia, Alito, and Chief Justice Roberts dissented, claiming that factors like the age of the child, the sadistic nature of the crime, and the number of times that the crime actually occurred should be factored in. And there shouldn't be any wholesale prohibition on applying the death penalty to cases where this could be a true factor on whether the death penalty should be imposed or not. What happens if the child is alive, but essentially is a vegetable? So now that the Supreme Court has a 6-3 conservative majority, Governor DeSantis is hoping that this new conservative majority on the Supreme Court can overrule this prior precedent and allow this law to go in effect. Now, this was the same tactic that was used to overturn Roe v. Wade, where the Dobbs Court, the current Supreme Court, overruled Roe versus Wade, claiming that the precedent was bad. Now, Florida is also making it easier to send someone to death row. See, in every state except for Alabama, you need a unanimous jury verdict to send people to death row. But now Florida is allowing juries to send inmates to death row with a vote of 8-4. Or about 67% of the jurors have to agree. Now, DeSantis says that once a defendant in a capital case is found guilty by a unanimous jury, one juror should not be allowed to veto a capital sentence. Now, Florida Governor DeSantis is changing the law in response to the Parkland shooter case, where the defendant was found guilty unanimously of the crimes, but only 9 jurors voted for the death penalty, with 3 jurors voting against it, which spared the shooter from death row.
Well, there's outrage tonight in Florida from the parents of the victims of the Parkland school shooting. A jury spared convicted killer Nikolas Cruz from the death penalty and instead recommended a sentence of life without parole for the 2018 massacre of 17 students and staff. CBS's Manuel Bojorquez spoke to some of the disappointed family members outside the courthouse.
Are suffering, and this result made them suffer even more. All the moms, now they are saying, okay, I guess this murderer who can murder my kid and still be alive. All their dads, they have to live knowing the fact that the murderer is in the jail every single day, breathing, eating, and getting help by their lawyers. Well, their kids was murdered on that day.
Florida law requires a unanimous decision for a death sentence. Benjamin Thomas, the jury foreman, said 3 of the 12 jurors voted that factors, including mental illness brought up by the defense, should take the death penalty off the table.
That's how the jury system works. Everybody gets their vote. Everybody gets to decide. You know, we went through all the evidence, and some of the jurors just felt that was the appropriate sentence.
Now, these changes to Florida's death penalty statute is making it easier for the state of Florida to essentially kill people and has gotten some criticism. Now, the biggest criticism is that the state of Florida, by far, leads the nation in the amount of death row exonerations on record since 1973. That means these people were on death row and were innocent. So changing Florida law to make it easier for people to get on death row doesn't seem like the thing to do when you have the most mistakes of sending people to death. So critics are saying that even when you required unanimous juries, you still had the highest amount of people on death row who were innocent, the highest amount of exonerations. Now, this is Herman Lindsey, who was exonerated from Florida's death penalty. He argues that not allowing unanimous verdicts in the penalty phase diminishes the jury's responsibility and deliberative process, and that we need to fix and find a way to fix our system and not continue to break it. So how do you feel about the state of Florida making it easier for the state to take its lives of its citizens? Do you think the death penalty should be extended to crimes where the victim lives? Should unanimous jury verdicts be required to sentence someone to death? Let me know how you feel in the comment section. My name is Nate the Lawyer, and I'll see you in the next one.